For unlisted matter, from supplementary list, item number 1.
We'll finish the rest of the matter and come back.
From the main list, item number 1.
May we please, Your Lordship? Your Lordship, I filed a missed case praying for leave of Your Lordship to allow me to file this writ petition before the division bench for the reason that the penalty order was passed by the division bench for 50,000 and debarred from appearing any government jobs, Your Lordship. That means the reason that I have filed this grave leave.
Your application is for review or recalling an order.
No. Application is to rule for the committee has decided that I am tainted against the decision of the committee. Because similarly situated tainted teachers were kept in the service, Your Lordship. I can give all the comparison table has been made.
Very good. So what do you want us to do now?
I crave leave of Your Lordship to allow me to move the writ before this division bench.
Division bench.
Yes.
Very well. Leave is given to the petitioner to move the petition before the division bench. Paragraph MCWPC 200 of 2022 is disposed of. Paragraph WPC number 475 of 2022 will appear immediately after the vacation. Full stop, all respondents should be served, comma, if not already done.
Already served, Your Lordship. Already served the copies.
MC so-and-so is disposed of without cost, sir. Yes.
Deeply obliged.
Item number 2.
So, Lordship, I crave leave that 1-2 pages were type copy to be allowed to be inserted in the writ.
You do it, we'll
Yes, sir, deeply obliged.
Please, Lordships. Who is appearing for the state of Assam?
May I please, Your Lordship? My Lord, I appear for the state of Assam.
Have you filed an affidavit?
My Lord, I appear for 1 week time, my Lord. There is a recent development, my Lord, regarding the investigation. Earlier, my Lord, it was conducted by the Assam Police, but now it has been handed over to the VIEO, my Lord. To that effect, my Lord, I want to bring it on record by filing an affidavit.
Since the state of Assam seeks further time to file its affidavit, comma, the time for such purpose is extended by a week from date. The matter will appear immediately after the vacation.
So, Lordship, I have a prayer, because with this next item number 3, since this has taken care of the PL, that can be closed, Your Lordship, Michael T. Sharma.
Will. It's appearing together with this?
Yes.
Lordship, yes. Item number 3.
Item number 3.
That's PIL number?
Not PL,
WPC, Your Lordship.
195 of 2020.
Very well. It is submitted on behalf of the writ petitioner in WPC number 195 of 2022 that since PIL number 8 of 2022 deals with the same matters incorporated in the writ petition, comma, the writ petition may be closed, paragraph, accordingly, comma, WPC number 195 of 2022 is disposed of without going into the merits thereof and leaving all questions open. Full stop, there will be no address to cause.
On behalf of the respondent, actually, we are mentioning.
You're making it on behalf of the respondent. That's very good. On behalf of the respondent.
Lordship, one small submission.
Who's for the petitioner?
We are for the petitioner, Madam.
Lordship,
one small submission. This matter which has been disposed of, in the last occasion I had made a submission in Lordship. There was an inquiry done by a magistrate to find out the legality of it. The inquiry had clearly given a clean sheet. So that will slightly have a bearing if the records are only tagged for the purpose of.
You use it as part of the records of the PL.
Yeah, Lordship, yes, because we may have to.
Since the writ petitioner, not, whereas the writ petitioners, the respondents, all right? And then last, the petitioner has no objection to the order, then dispose it of. And finally, since the state had caused an inquiry to be conducted subsequent to the filing of this petition, the report of the inquiry may be cited in course of the public interest.
Absolutely.
All right, Your Lordship.
Item number 4.
Lordship, Mr. Chakrabarti is appearing this matter. Who? Mr. Chakrabarti. He's in
That's all
disposed. Lordship, this is a
Yes,
matter.
what is the matter about?
Lordship, we have come challenging the assessment order.
Has that been revoked?
Still pending, Lordship. Lordship, on 5th December, we have mentioned the matter, Lordship.
We can't go on endlessly. You can't get the matter taken up by the other High Court. We'll have to dispose of this petition with liberty to them to act in accordance with law. We can't go on endlessly. A probate application, revocation of probate, you can't get it heard for so many months. The petitioner says that despite mentioning the matter before the Calcutta High Court on repeated occasions, the application for revocation of the probate has not yet been taken up. Paragraph. It is hoped that the petitioner will be able to persuade the Calcutta High Court to take up the matter within the next 2 months. Full stop. Let the present petition appear. 3 months hence, the subsisting interim order will continue.
Congratulations.
Second call from supplementary list, item number 1.
My Lord has such an important issue, therefore, Lordship is has to take a forensic examination of this very issue.
Sorry?
Lordship has examining this forensic manner, my Lord. My Lord, the honors is so very heavy for me to persuade my Lord.
No, you do your best. And we hope that we give you enough opportunity to make out your case, because that is the only thing that you can expect of a court, to give you a chance to put your case.
My Lord.
Yes.
My Lord. And Lordship decision will play the part for justice delivery system in a tribal area. Now, the language of the...
You see, if you look at it in a slightly informal way, this province of Assam has been in existence for quite a long time. Even prior to independence, a rudimentary form of justice delivery system had already been set up by the colonial rulers over here. To the extent, such part of Assam was under their control. We accepted that Meghalaya was not under their control. We accept that several other areas were in the northeast, which ultimately came to be within the state of Assam once the state was constituted post-independence. 1898 mechanism and the 1937 rules. In the state of Assam, the justice delivery system was kind of structured. After the 6th schedule comes, it says that when matters are between tribal and tribal, then ordinary court structure will not. It will only be the district council courts or the autonomous, the other form which is not here, regional council courts which will take up. But here, there were district council courts which were set up or which may have been in existence prior to that. So in tribal versus tribal, what the sixth schedule also pressed, the ordinary scheme
Yes.
of things will prevail.
Yes.
Also the sixth schedule gave a special power to the governor to confer authority outside the district council in respect of heinous offences and other matters that the governor deemed fit. That of course has to be in consultation or on the aid and advice of the Council of Ministers headed by the Chief Minister of the state. So there is one non-tribal system in place, the general system in place, there is a unique tribal system in place, and no gaps in between.
Yes.
There is no doubt that what you are saying has some substance because the Civil Procedure Code was not applied, the Criminal Procedure Code had not been notified, so therefore, who is the district and sessions judge? That animal is unknown over here
Well,
in the state of Meghalaya because they have not. But since there was a general system of general justice delivery system and a specialized justice delivery system already in place, forget that the executive was also discharging judicial functions. But since this was in place in 1972, prior to the state of Meghalaya being born, when the state of Meghalaya was born, it was born with the twin systems.
yes.
Then there could never have been any gap.
Yes.
So even if we don't refer to the de facto doctrine, we can go by intendment. Because in the larger scheme of things, there is a general mechanism, there is a special mechanism, with authority to the governor to take out matters from the special mechanism and park it with the general mechanism, or invest the special mechanism with more authority. So the intendment in this, the milieu has to be realized to understand what may have been the intention of the notifications. Technically, you are right. King Emperor Nazir Ahmed says, when a thing has to be done in a particular way, it has to be done in that manner, in that way, and in no other manner. But when the intention is to do that thing, and accidentally there is a technical omission or a technical fallacy, but the intention is evident, then even without resorting to the de facto doctrine, one can say that this was supposed to be the purpose. Now you address us on whatever.
My Lord, Lordship has got exactly prior to independence and even during independence, normal judicial structure is available. Now, after 6th schedule came into being, that special judicial structure for the autonomous is come into being under para 4. Now, another special power was conferred to the governor under subpara 1 or para 5. My Lord. But that special power is with regard to the special arrangement, not to the normal arrangement, as I understand. Now, intendment Lordship may unearth, I bow down to that, my Lordship, with discretion. The language of the para 5, subpara 1 or para 5, it is very clear that governor can confer power on the appoint and confer power upon any officer. Now, 2008 notification heavily relied by learned AG. It is not the officer. It is the district and session.
Maori.
Maori was in 2015.
Okay.
Subsequent notification came in 2018.
It was in the name of district and sessions judge.
The name of district session judge. Now that in the
Ex officio.
my Lord. That my humble submission, my Lord, this 2018 conferment on the office or on the session judge, it is not in consonance with this Subpara 1 or para 5. Para 5. Therefore, that notification of 2018 can be read within the spirit.
Why do you say that?
No, para 5, Lord. Subpara 5. 6th schedule, let us look together, Your Lordship. Allow. Subpara 5, if Lordship allow me to read. May I read, my Lord? The Governor may, for the trial of suits or cases arising out of any law in force in any autonomous district or region being a law specified in that behalf by the Governor, or for the trial of offences punishable with death, transportation for life, or imprisonment for a term of not less than 5 years under the Indian Penal Code or under any other law for the time being applicable to such district or region, confer on the district council or regional council having authority over such district or region, or on courts constituted by such district council, or on any officer appointed in that behalf by the Governor. Such powers under the Code of Civil CBC, or as the case may be, CRPC, as deemed fit appropriate, and thereupon the such council, court, or officer shall try the suit, cases, or offences in exercise of such power to so confer. Now, I see, my Lord, I see one is district council, two is regional council, third is, my Lord, court constituted by the district council, or fourth is an officer, my Lord. Now, the Governor confirming, as I disclosed yesterday, was an officer. Now, 2018 judgment relied by learned AG, confirming to session judge, is not an officer. He is not an officer. Therefore, this conferment by the Governor 2018 is out of this subpara. Therefore, in view of that, my Lord, that 2018 judgment can be looked from the spirit of 37 rule, 1950 rules, not from the perspective of, my Lord, subpara 1 or subpara 5. Itself, my Lord, apparently on the face of it, my Lord, my humble submission is that 2018 notification conferring power upon the district and session judge, no more, is not, my Lord, within the purview of subpara 1.
2018.
18, my Lord.
Third
18, my Lord.
third meeting.
That is the last, my Lord.
That is page 176.
Yes.
My Lord, 176. 176. Therefore, in this 176 page, Governor has quoted subpara 1.5. It is by mistake, but by mistake, perhaps. He has quoted. But the intent therein is, according to me, he is exercising the power under 37. And that
37 rules.
37 rules, read with 1960. Not subpara 1 or para 5. My Lord.
So there's a different authority under 37 rules. Show us that authority.
37, my Lord. 37 rules. My Lord, page 9 of that very compilation. Page 9. May I take, my Lord? Rule 1A. Rule 1A may read, my Lord. Power of Governor to appoint additional Deputy Commissioner. The Governor may, when he thinks fit, appoint an additional Deputy Commissioner, either generally or for the trial of a particular case or particular cases, civil or and criminal, and may direct that such additional Deputy Commissioner shall, for the general or special purpose of say, exercise all or any of the powers of the Deputy Commissioner. He has quoted in 2018 notification, and as well as 1960 rules, 1960 Act. But that is available in page number 90.
90.
90, my Lord. 90. My Lord. section, I will say section 2. He has quoted this one. May I read? Notwithstanding anything contained in the rules for administrative justice and police in the Autonomous District as adapted and modified by the Assam Autonomous Administrative Justice Regulation 1952 and also enforced for the time being or in any other law enforced, the state government may, when it thinks fit, appoint one or more additional deputy commissioner for an autonomous district, either generally or for the trial of a particular case or particular cases, civil or criminal, and may direct that such additional deputy commissioner for the general or special purpose of, say, exercise all or any of the powers of the deputy commissioner. Therefore, my respectful submission, therefore.
Either way, even if he had not done it under Schedule 6, if he's done it under 37 rules, or if it has been done under the 60 Act, it still gives him the authority?
But he keeps an authority. But this is for the purpose of the so-called Lordship was initially pointed out, general structure, judiciary, my Lord. This is for this purpose. Lordship has rightly pointed out the prior to independence or after arrival of the Constitution of India also, general judicial structure is available. That structure is available under this 37 and read with this 60. And under that, my Lord, to discharge that functions, my Lord, Governor has been conferred power to appoint the ADC. And the intent, my Lord, my humble submission is 2018 conferment is with this, my Lord, with these two acts and rules, purely for the purpose of trial of the cases as a general structure, general district judiciary, for when both the parties are either tribal or non-tribal. Right. Therefore, earlier in my occasion, with Lordship permission, I pointed out that had the governor never conferred power to the officer of district council, by virtue of this act, my Lord, ADC try all the cases, irrespective of parties coming from both the parties are tribal or not. ADC try the cases, session cases. But in view of this, invoking the power by the governor under Sapara 1, when both the parties are tribal, only the district council officer appointed by the governor in that behalf is the competent authority to try the case.
We do the last part, just repeat why?
My Lord. Now, had the governor, my Lord, never invoked Sapara 1 or Sapara 5 of the independence of India, my Lord. Still, my Lord, the ADC under 37 Red with 1960, ADC exercised all the session powers, and therefore, irrespective of parties, either both the parties are tribal or non-tribal, my Lord, it can be tried by the ADC as a general judicial structure in the district level. However, because of the special arrangement carved out under the 6th schedule, and governor has judiciously, my Lord, invoked his power, and therefore, appointment of the district council officer as a officer of the office appointed by the governor is the only authority to try this. Now, I will not take a longer time. Lordship has given me enough time. I'm conscious of this. London AG also relied on the de facto doctrine. I have, my Lord, I have gone through some judgments, and if Lordship allow me, I will place some judgment. To begin with, my Lord, King Emperor case. May I read out the relevant portion where Justice Mukherjee has laid down the law, my Lord. That his relevant para, but the page, my Lord, the copy of the compilation, Lordship, page 22 of the compilation itself.
Which compilation? Volume 1?
This 2011 SSC online, Calcutta.
Compilation.
Right. Lordship, on the occasion, we have a copy from Lordship's record.
Do we have 2011?
I have a spare copy.
So, 1911 SSC.
Do we have that online?
Online. It is available in the record on the occasion.
That the calculator lawyers had given. Could it be Adidas?
Well, I'm referring to that one.
2011 SCC online.
1911 SCC online, Calcutta, in the High Court of Calcutta, criminal appellate jurisdiction. Pulin Bihari Das versus King Emperor.
Copy may not be there because it was part of other.
Right. My lord, in that case, running page number 22, second paragraph, my lord. It is well settled.
Just a second.
My lord.
Yes.
My lord, second paragraph, my lord, page 22. It said, my lord, it is well settled that the acts of one who, although not
Page-
the
page
judicial
numbers.
order, page 22 of this, my lord. Page 22 of the very judgment, second paragraph.
You don't have a page 22.
Page 22, my lord. Paragraph is not given, but running page 22, I refer.
Top,
Running page of what?
top left, your lordship, page number is mentioned, top left. In a small font, my lord. Second line.
Yes.
My lord. It is well settled, yes.
Yes.
It is well settled that the acts of one who, although not the titular holder of a legal office, was actually in possession of it under some color of title or any such condition as indicated, the acquiescence of the public in his action could not be collaterally impeached in any proceeding to which such person was not a party. Parker killed and sons, my lord. The view, however, it is important, my lord. The view, however, has sometimes been maintained that there can be no de facto officer when there is no office de jure. Well, de jure. Not only shall be such. But the contrary opinion has been maintained upon weighty reason. It has been held that an unconstitutional law emphasizing an office, establishing an office, may, until such law has been declared unconstitutional, be regarded as conferring color of title, and the incumbent of such office should be treated as a de facto officer. the two fundamental prerequisites to the existence of de facto officer are, first, the position of the office and the performance of the duties attached to it. Secondly, color of title, that is apparent right to the office and the acquiescence in the possession of it by the public. Now, according to me, my lord, here it says that the Honorable Justice Mukherjee said that, my lord, he referred that if there is no de jure office, the question of application of de facto do not arise. In this case, my lord, in King Emperor case, de jure office of session judge was already there. The only question was, my lord, the sanction was given by the unauthorized provincial government. Therefore, the doctrine of de facto was applied. But here the difference here in my case is, my lord, admittedly there was no de jure session judge in Nongpo. De jure in Nongpo. Therefore, my lord, once a de jure office session judge is not there in Nongpo, Ripoy district, the question of possession, exercising the public duty do not arise. My lord, I would ask to myself, my lord, question myself, my lord, if there is de jure office session judge in Nongpo, and one judicial officer was illegally conferred or appointed, but he discharged the duty, public duty attached there. My lord, he is not the intruder. He cannot be considered as a usurper. My lord. But in my case, it is completely different situation. De jure office was not there. Now, with this case also referred by the Honorable Tax Court in 1981, 3-bench judgments, my lord, with lordship permission, may I place this one? I've given the list of books. 1981, volume 3 ACC, page number 132. My lord, in this case, the learned and district session judge were appointed, and he assumed the judicial office, tried number of cases, pronounced number of judgments, and later on, my lord, somebody challenged his appointment, and the Supreme Court has set aside his appointment on the ground of illegal process. Now, the judgment, some of the judgment delivered by him was under appeal before the High Court, and after Supreme Court set aside his appointment, the appellant took this issue that the judgment delivered by those session judge can be treated as null and void. Now, this is the answer. Here, the Honorable Tax Court, 3-bench judgment has referred many judgments of England and Australia and even USA, and King Emperor case also. If we start, lordship, from page, the para 4. Para 4. Elaborately discuss about this de facto doctrine. With lordship permission, may I read? Para 4. We are unable to agree with the submission of the learned counsel for the appellants. The doctrine is well established that the acts of the officer de facto performed by them within the scope of their assumed judicial authority in the interest of public or third persons and not for their own benefit are generally as valid and binding as they were the acts of officer de jure. Well, King Emperor case is quoted here, relied here. As one of us had occasion to point out earlier, the doctrine is founded on good sense, sound policy, and practical experience. It is aimed at the prevention of public and private mischief and the protection of public and private interests. It avoids endless confusion and needless chaos. An illegal appointment may be set aside and a proper appointment may be made, but the acts of those who hold office de facto are not so easily undone and may have lasting repercussions and confusing sequels if attempted to be undone. Hence the de facto doctrine. In Bulin Bihari versus King Emperor, Sir Asutosh Mukherjee Justice noticed that in England, the de facto doctrine was recognized from the earliest times. The first of the reported cases where the doctrine received judicial recognition was the case of APT Fontaine decided in such. Sir Asutosh Mukherjee noticed that even 1431, the de facto doctrine appeared to be quite well known. And after 1431, the doctrine was again and again reiterated by the English judges. Well, in Millward and Thatcher, polling justice said, well, the question whether the judges below the properly judges or not can never be determined. It is sufficient if they can be judges de facto. Suppose a person were even criminally convicted in a court of record, and the recorder of such a court were not duly elected, the conviction would still be good in law, he being the judge de facto. In Scathing versus Lauren, the question arose whether a rate for the relief of the poor was rendered invalid by the circumstances that some of the vestry men who made it were vestry men de facto and not de jure. The Lord Chancellor observed as follows: with regard to the competency of the vestry men who were vestry men de facto but not vestry men de jure to take the rate, your lordships will see at once the importance of that objection when you consider how many public officers and persons there are who were charged with very important duties. And those titled to the office on the part of the public cannot be ascertained at the time. You will at once see to what it would lead if the validity of their acts when in such office depended upon the propriety of their election. It might then, if doubts were cast upon them, to consequences of the most destructive kind. It would create uncertainty with respect to the obedience to public officers, and it may also lead to persons, instead of resorting to ordinary legal remedies, to set right anything done by the officer, taking the law into their own hands. Some interesting observations were made by the Court of Appeal in England in Regime's case, but though the learned judges constituting the Court of Appeal differ on the principal question that those before them, namely whether the Court of Rhodesia was a British court, there did not appear to be any difference of opinion on the question of the effect of the invalidity of the appointment of a judge on the following judgment pronounced by him. Lord Denning categorically said, he sits in the seat of a judge. He wears the robes of a judge. He holds the office of a judge. Maybe he was not validly appointed, but still he holds the office. It is the office matter is important. It is the office that matters, not the incumbent. So long as the man holds the office and exercises it duly and in accordance with law, his orders are not nullity. If they are erroneous, they may be upset on appeal. But if not erroneous, they should be upheld. Lord Denning then proceeded to refer to the state of Connecticut versus Carroll, decided by the Supreme Court of Connecticut, decided by the Court of Appeal in New Zealand, and Norton and Shelley County, decided by the United States Supreme Court. Observation in the last case were extracted, and they were: where an office exists under the law, it matters not how the appointment of an incumbent is made. So far as the validity of his act are concerned, it is enough that he is clothed with the insignia of the office and exercises its powers and functions. The officer's act of such persons are recognized as valid on grounds of public policy and for the protection of those having official business to transact. Scarman, my Lord, Justice, who differ from Lord Denning on the question whether the Court of Rhodesia was a British court, appeared to approve the view of Lord Denning in regard to de facto doctrine. He said, Lord Denning invokes the doctrine of recognition of the de facto judge and the doctrine of implied mandate or necessity. I agree with much of the thinking that lies behind his judgment. I do think that in appropriate case, our courts will recognize the validity of judicial act, even though they may be the acts of judge not lawfully appointed or derive their authority from the unlawful government. But it is a fallacy, my Lord, to conclude that because in certain circumstances our courts would recognize as valid the judicial acts of an unlawful court or de facto judge, therefore the court does recognize a British court. The de facto doctrine has received judicial recognition in the United States of America also. The state of my Lord, third edition, the question arose whether the offer of a bribe to a city commissioner whose appointment was unconstitutional as an offence. But Braturi Justice said that we think that the principle of public policy declared by the English courts 3 centuries ago, which gave validity to the official acts of persons who intruded themselves into an office to which they had not been legally appointed, is as applicable to the condition how presented as they were to the condition that then confronted the English judiciary. We are not required to find a name by which officers are to be known, who have acted under a statute that has subsequently been declared unconstitutional, though we think such officer might aptly be called de facto officers, my lord. Now, in Newton and Shelley, my lord, the doctrine which gives validity to the act of officer de facto, whatever defects there may be in the legality of their appointment or election, is founded upon consideration of public policy and necessity for the protection of public individual whose interests may be affected thereby. Offices are created for the benefit of public, and private parties are not permitted to inquire into the title of persons clothed with the evidence of such offices in the apparent possession of their powers and function. For the good order and peace of the society, their authority is to be respected and obeyed until, in some regular mode prescribed by law, their title is investigated and determined. It is manifest that endless confusion would result if every proceeding before such officers, their title would be called in question, my lord. The last paragraph may read, my lord. In constitutional limitation, my lord, an officer de facto is one who has some color or right is in possession of an office and for the time being performs in duties which public acquiescence, though having no right in fact. His color of right may come from an election or appointment made by some officer or body having colorable, but no actual right to make it, or made in such disregard of legal requirement as to be ineffectual in law, or made to fill the place of an officer illegally, removed or made in favor of a party not having the legal qualification, or it may come from public acquiescence in the qualification, or it may come from public acquiescence in the officer holding without performing the procedural condition, or holding over under claim of right after his legal right has been terminated, or possibly from public acquiescence alone when accompanied by such circumstances of officer reputation as are calculated to induce people without inquiry to submit to or invoke official action on the supposition that the person claiming the office is what he assumes to be. An intruder is one who attempts to perform the duties of an office without authority of law and without support of public acquiescence. No one is under obligation to recognize or respect the acts of an intruder, and for all legal purposes, they are absolutely void. But for the sake of order and regularity, and to prevent confusion in the conduct of public business and the security of the private rights, the acts of officer de facto are not sufficient to be questioned because of the want of legal authority, except by some direct proceeding instituted for the purpose by the state, or for someone claiming the office de jure, or except when the person himself attempts to build up some right or claim some privilege or emolument by reason of being the officer which he claims to be. In all cases, the acts of an officer de facto are as valid and effectual while he is supposed to retain the office, as though he were an officer by right, and the same legal consequences will flow from them for the protection of public and third parties. There is an important principle which finds concise expression in the legal maxim that the acts of officer de facto cannot be questioned collaterally, my lord. This was, my lord, in the last para 19. It was held by the Apex Court held para 19, the last para. It says that, in our view, de facto doctrine furnishes an answer to the submission of Sri Praki based on Section 9 Criminal Procedure Code and Article 21 of the Constitution. The judges who rejected the appeal in one case and convicted the accused in the other case were not mere usurpers or intruders, but were persons who discharged the functions and duties of judges under the color of lawful authority. We are concerned with the office that the judges purported to hold. We are not concerned with the particular incumbents of the office. So long as the office was validly created, it's important matter, validly created, it matters not that the incumbent was not validly appointed. A person appointed as a session judge, additional session judge, or assistant session judge would be exercising jurisdiction in the Court of Session, and his judgment and orders would be those of the Court of Session. They would continue to be valid as judgment and orders of the Court of Session, notwithstanding that his appointment on such court may be declared invalid. On that account alone, it can never be said that the procedure prescribed by law has not been followed. It would be different matter if the constitution of the court itself is under challenge. We are not concerned with such a situation in the instant case. We therefore find no force in any of the submissions of the learned.
Why are you citing this? All of this is against you.
My Lord,
It's in my favor.
Paragraph 19 is completely against you.
My Lord, my humble submission, my Lord, understanding, my Lord, if the office is created, if the teacher office is there, my Lord, then whatever appointment, illegal appointment is made, right, the action taken by those officers is, my Lord, valid by applying the de facto. But if the office is not created, if the teacher office is not there, my Lord, the doctrine is not applicable. That's what I understand, for Lordship.
It will be attribute that argument to you, but the finding, the ratio is not that. The ratio is if the constitution of the court itself is under challenge.
Right.
The constitution of the court itself is not under challenge. You say that it's been irregularly, the authority has been irregularly conferred. But that there was someone discharging the duties of a district judge is not questioned, even though CPC, CRPC may not have been there.
My Lord, what I'm questioning is that, my Lord, the session judge was not there. Therefore, the action taken by the session judge in report, my Lord, cannot be saved by application of a de facto. That is my
Very, we
understanding.
followed.
My Lord.
Anything else?
Another judgment, my Lord, with that.
Just make
1980
a copy of this and
1987.
put it in the file.
My Lord, 1987 supplementary, SEC page 410. 401.
1987
87 supplementary, SEC 401, relevant para 20. Here this one also, some illegal appointment was made, and the party claimed that the action taken by those officers cannot be saved by application of de facto doctrine. But the High Court and the Honorable Apex Court applied that principle. Page 20.
Paragraph 20 you said.
Paragraph 20, my Lord. Paragraph 20. The same legal principle. We have recorded findings that 21 unplaced candidates of 1970 examination were appointed to service illegally in breach of rules. We would, however, like to add that even though their appointment was not in accordance with law, but the judgment and order passed by them are not rendered invalid. The unplaced candidates are not usurpers of office. They were appointed by the competent authority to the post of munsifs with the concurrence of the High Court, though they had not been found suitable for appointment according to the norms fixed by the Public Service Commission. They have been working in the judicial office service during all these years, and some of them have been promoted also, and they have performed their functions and duties as de facto judicial officers. A person who is ineligible to judgeship, but who has nevertheless been duly appointed and who exercises the powers and duties of the office is de facto judge. He acts validly until he is properly removed. Judgment and orders of the de facto judge cannot be challenged on the ground of his ineligibility for appointment. This doctrine, my Lord, the earlier judgment was quoted, my Lord. Here, what I'm trying to bringing home Lordship attention is that if there is
Office and person.
my Lord, teacher office is there, my Lord, doctrine is applicable. If there is no teacher office, doctrine is not applicable. In the last decision, may I please, 2016, volume 14.
2016 volume,
My Lord, volume 14, SCC,
page
page number 18.
1.8.
Well, relevant para would be para 34. Here, Apex Court also say that, para 30. Doctrine is not universal application, my lord. What I understand, para 34. Para 34, may I read, my lord. It is no doubt well settled that the acts of officers de facto performed by them within the scope of their assumed authority in the interest of public or third persons and not for their own benefits are generally held valid and binding as if they were the acts of the officer de jure. A reading of the said paragraph does not give an omnibus authority, even while applying the de facto doctrine, to hold that every illegal act or acts performed by which smacks of very many illegalities in incongruities should be merely ignored and validated. It has to be kept in mind that even while applying the de facto doctrine, whether such acts performed were aimed at the prevention of the public and private mischiefs and for the protection of public and private interests, the doctrine is intended to prevent invalidation of acts such as appointments on the sole ground that they were performed without de jure authority. Therefore, keeping in well thought out principles set down in the sage judgment in mind, when we examine the approach of the division bench, we find that the division bench, having noted that the respondent number 4 to 9 in the petition ceased to hold office, had to be necessarily not dealt with the challenge made to their appointment for issuance of quo warranto. It also rightly applied de facto doctrine, but the approach of the division bench in stating that even while applying the de facto doctrine, the selection made require deeper scrutiny cannot be held to be improper, my lord. Here also what happened in this case, the appointment was made, some officers were appointed and they performed the duty. Later on it was challenged. Therefore, my lord, the matter came up, the High Court says that, my lord, the action done by those officers is safe by de facto doctrine.
See, this comes up like over here.
Yes.
This comes up in rare cases when a quo warranto is sought. What is a quo warranto? A person has usurped authority. What is the writ of quo warranto? That you prohibit a person from usurping authority that he does not possess. If that writ is granted, prospectively his authority goes. But if he had been validly appointed, let us say I require a basic qualification of law and I did not possess that qualification, but I was erroneously appointed. When the writ is issued, quo warranto, I cease to hold office. But the acts that I did in discharge of my official duties do not get affected by my removal from office.
Yes, yes.
That is the de facto doctrine.
My
And that is what is applied over here, even in Justice Bobde's judgment.
lord.
And that is the essence of Pulimbi Haridas, which, as we told you about the general and the special, goes completely against you, probably, your judgments. Any other?
Oh, my lord, with that, lordship.
We understand the distinction that you are trying to make.
Yes.
You are trying to make a distinction between the person and the office. You say that de facto doctrine does not apply when the office itself is in challenge, but the office is not in challenge over here. Your thing is that the office is not in existence.
Existence, not in existence.
Not that the office is in challenge. Office is not in existence.
Exactly.
We'll look into that.
My lord, lordship court. The last judgment with regard to fact and valid, my lord. Fact and valid is the last judgment, my lord. May I take lordship attention to, my lord, my lord, 2008 volume 13 ACC. Page number, my lord, 119. My lord, this with regard to adoption.
Page 119.
119, my lord. Relevant para would be, with lordship permission, I may rely on para 10, 12, 28 and 29.
10, 12?
28 and 29. This would be my last judgment, my lord. But 10 and 12, let us see, my lord, the issue, my lord. My lord, the defendant 2 and 4 in their written statement were adopted by the pleadings of defendant number 1 and categorically alleged that according to Hindu customs, sister sons cannot be adopted. Hence, alleged adoption of Chandrapan by Jagannath was against law. On the pleading of the parties, the trial court framed a number of issues. Relevant issues are issues number 1 and 2, which were as follows. Whether a custom was prevalent in Vanish community to validate the adoption of the sister. Whether Jagannath had been legally adopted, Chandrapan as a son. If so, what is its effect? Now, para 28, madam. In para 28. Madam, in yet another decision reported in Himsing versus Herman Singh, this court observed that the custom recorded in Red Reward M is in derogation of the general custom, and those who set up such a custom must prove it by clear and unequivocal language. Similarly, when a custom is against the written text of the Hindu law, then one who sets up such a custom must prove it by a clear and unequivocal language. It may also be pointed out that the settled law is that for a valid adoption, not only the person adopting should be capable of lawfully taking in adoption, but the person giving must be capable of lawfully giving in adoption, and the person adopted must be capable of being lawfully taken in adoption. It is necessary that all these three conditions must be satisfied, and it is not sufficient that one of them is satisfied. In Himsing, this court quoted with approval some of the observation in Murasan's and such matter. It has similarly been held that the texts which prohibit the adoption of an only son and those which enjoin the adoption of a relation in preference to a stranger are only directory. Therefore, the adoption of an only son or a stranger in preference to a relation, if completed, is not invalid. That in cases such as above, where the attacks are merely directory, the principle of factum valid applies, and the act is valid and binding. But such thereafter, the following observation occur in the same paragraph. But the texts relating to capacity to give, the capacity to take, and the capacity to be the subject of adoption are mandatory. Hence, the principle of factum valid is ineffectual in the case of an adoption in contravention of the provisions of this text. My lord.
Thank you.
Madam, this is my humble submission that it is not. Madam.
Mr. Advocate will hear you on 14th.
Yes, sir.
14th.
Yes, sir.
This is comprehensive
Yes,
and
sir.
finished.
My lord, with lordship permission, indulgence, only 14. I have one fixed matter in court, High Court. 15, is it possible, madam?
14th, we'll hear him primarily.
Yes.
If any difficulty, follow us virtually or something, come later, ask your juniors to be there. We'll be hearing him.
Yes, sir.
Thank you.
Highly appreciate.
Send it to me just.
I am grateful for your research.
Probably I'm not turning off.